that IEBC itself admitted that it had network problems which hindered its prompt transmission of results, but by the time of announcement of results, transmission had been completed. What was IEBC's answer to the above contention? In his submissions before us, Mr. Nyamodi, learned counsel for IEBC, outlined to the court the mode of the transmission process of the results and submitted that after the manual filling in of Form 34A, the POs then keyed in the results into the KEMS kit, took the image of the Form 34A, and then simultaneously transmitted the same to the constituency and national tallying centers. Our understanding of this process is that the figures keyed into the KEMS corresponded with those on the scanned images of Forms 34A. In these circumstances, we do not understand why those figures, which learned counsel referred to as mere statistics, that did not go into the determination of the outcome of the results, differed. In these circumstances, bearing in mind that IEBC had the custody of the record of elections, the burden of proof shifted to it to prove that it had complied with the law in the conduct of the presidential election, especially on transmission of the presidential election results, and it failed to discharge that burden. Of further note is that IEBC strenuously opposed the petitioner's application for access to its servers, claiming that such access would compromise the security of the data in those servers. After considering the application, we overruled that objection and partly allowed the same. Though we did not therefore accept IEBC's said claim of compromising the security of its servers, considering the fact that having spent billions of taxpayers' money, IEBC should have set a robust backup system, nevertheless, to assuage those fears, we granted the petitioners a read-only access, which including copying where the petitioners so wished. The report from the court-appointed IT experts, Professors Joseph Sevilla and Elijah Omwenga, holders of PhDs on IT and lecturers in Strathmore and Kabianga universities respectively, shows clear reluctance on the part of the IEBC to fully comply with this court's order of the 28th August 2017 to provide the information requested. In summary, the following are the items that were not availed to the petitioners and to the third respondent and the court. A, firewalls without disclosure of the software version. IEBC refused to provide information on internal firewall configuration, contending that doing so would compromise and affect the vulnerability of their system. The court-appointed ICT experts disagreed with that contention and said it was difficult to ascertain whether or not there were any hacking activities. B, IEBC was also required to provide certified copies of the certificates of penetration tests conducted on the IEBC election technology system prior to and during the 2017 election pursuant to Regulation 10 of the Elections Technology Regulations. I'll take that again. IEBC was also required to provide certified copies of the certificate of penetration tests conducted on the IEBC election technology system prior to and during the 27 election pursuant to Regulation 10 of the Elections Technology Regulations 2017. These were not provided. Instead, IEBC issued and certified documents and certificates by professionals which did not conform to the regulation. C, IEBC was also required to provide specific GPRs each KEMS kit used during the presidential election for the period between the 5th August 2017 and the 11th August 2017. This was not provided. IEBC instead provided the GPS locations for the polling stations, which was not ordered to be granted. D, documents for allocated and non-allocated KEMS kits procured was provided. However, the information on whether the kits were deployed or not was incomprehensive. E, the court ordered access to technical partnership agreements for IEBC election technology system, including a list of technical partners, kind of access they had, and list of APIs for exchange of data with partners. The documents were issued with the exception of the list of APIs. The court-appointed ICT experts said full information on APIs would have enabled determination of what kind of activities may have taken place. The court had also ordered IEBC to provide the petitioners with the login trail of users and equipment into the IEBC servers, the login trails of users and equipment into the KEMS database management systems, and the administrative access login into the IEBC public portal between the 5th of August 2017 to date, being the date of the court order, which was the 28th August 2017. These were also not provided. Instead, IEBC provided pre-downloaded logs in a hard disk whose source it refused to disclose. The IT experts agreed with the petitioner's contention that the first respondent should have demonstrated that the logs emanated from the IEBC servers by allowing all parties to have a read-only access. Alternatively, the first respondent could have accessed the information in the presence of the petitioner's agents. Partial live access was also only purportedly provided on the 29th August 2017 at about 3:50 p.m. without ability to access the logs or even view them. The exercise was therefore a complete violation of the court order, and the access was not useful to the parties or to the court. It is clear from the above that IEBC in particular failed to allow access to two critical areas of their servers: its logs, which would have proved or disproved the petitioner's claim of hacking into the system and altering the presidential election results, and its servers with forms 34A and 34B electronically transmitted from polling stations and CTCs. It should never be lost sight of the fact that these are the forms that Section 39(1)(c) IBC's contumacious disobedience of this court's order of 28 August 2017 in critical areas leaves us with no option but to accept the petitioner's claims that the IBC's IT system was infiltrated and compromised, and the data therein interfered with, or IBC's officials themselves interfered with the data or simply refused to accept that it had bungled the whole transmission system and were unable to verify the data. The petitioners also made claims that some forms 34A supplied to them did not relate to any of the existing gazetted polling stations or tallying centers. That while 15,558,038 people voted for the presidential candidates, 15,098,646 voted for gubernatorial candidates, and 15 million. Sorry. The petitioners also made claims that some forms 34A supplied to them did not relate to any of the existing gazetted polling stations, tallying centers, that while 15,558,038 people voted for the presidential candidates, 15,098,646 voted for gubernatorial candidates, and 15,008,818 voted for members of parliament, raising the questions as to the validity of the extra votes in the presidential election. No satisfactory answer was given to the latter issue, and we must also hold the first respondent responsible for that unexplained yet important issue. Having therefore shown that the transmission of results was done in a manner inconsistent with the expectations of Section 39(1)(c) of the Elections Act, we must of necessity return to the principles in Articles 81 and 86 of the Constitution, which we have already reproduced. Of importance are the expectations of transparency, accountability, simplicity, security, accuracy, efficiency, and especially verifiability of the electoral process. These terms should be understood to refer to A, an accurate and competent conduct of elections where ballots are properly counted and tabulated to yield correct totals and mathematically precise results. B, an election with a proper and verifiable record made on the prescribed forms executed by the authorized election officials and published in the appropriate media. C, a secure election whose electoral processes and materials used in it are protected from manipulation, interference, loss, and damage. D, an accountable election whose polling station, constituency, and national tallies, together with the ballot papers used in it, are capable of being audited. And E, a transparent election whose polling, counting, and tallying processes, as well as the announcement of results, are open to observation by, and copies of election documents easily accessible to the polling agents, election observers, stakeholders, and the public, and as required by law, a prompt publication of the polling results forms is made on the public portal. Verifiability must have had strong significance in the 8th August election because the presiding officers were required to verify the polling station's results in the presence of polling agents before sending them to the CTC and NTC in using the KIEMS kit. The minor KI decision made it clear that Form 34A, being the primary document, becomes the basis for all subsequent verifications. We have already addressed the import of the refusal to obey a court order, and we further note that the whole exercise of limited access to the first respondents' IT system was meant to confirm and verify both the efficiency of the technology and also verify the authenticity of the transmissions allegedly made to the CTC and to the NTC. Non-compliance and failure, refusal or denial by the IEBC to do as ordered must be held against it. So, what of Article 138(3)(c) of the Constitution? It provides, in a presidential election, after counting the votes in the polling stations, the Independent Electoral and Boundaries Commission shall tally and verify the count and declare the results, unquote. The critical element here is the duty placed upon the Commission to verify the results before declaring them, to ensure that the results declared are the ones recorded at the polling station, not to vary, not to change or alter the results. The duty to verify in Article 138 is squarely placed on the Independent Electoral and Boundaries Commission, the first respondent herein. This duty runs all the way from the polling station to the constituency level and finally to the National Tallying Center. There is no disjuncture in the performance of the duty to verify. It is exercised by the various agents or officers of the first respondent, that is to say, the presiding officer at the polling station, the returning officer at the constituency level, and the chair at the National Tallying Center. The verification process at all these levels is elaborately provided for in the Elections Act and the regulations thereunder. The simultaneous electronic transmission of results from the polling station to the constituency and the National Tallying Center is not only intended to facilitate this verification process, but also acts as an insurance against potential electoral fraud by eliminating human intervention or intermeddling in the results tallying chain. This, the system does by ensuring that there is no variance between the declared results and the transmitted ones. In the presidential election of the 8th August 2017, however, the picture that emerges is that things did not follow this elaborate but clear constitutional and legislative roadmap. It has been established that at the time the second respondent declared the final results for the election of the president on the 11th August 2017, not all results as tabulated in Forms 34A had been electronically and simultaneously transmitted from the polling stations to the National Tallying Centers. The second respondent cannot, therefore, be said to have verified the results before declaring them. The said verification could only have been possible if, Before declaring the results, the second respondent had checked the aggregated tallies in Forms 34B. Against the scanned Forms 34A is transmitted in accordance with the provisions of Section 39(1)C of the Elections Act. Given the fact that all Forms 34B were generated from the aggregates of Forms 34A, there can be no logical explanation as to why, in tallying the Forms 34B into Form 34C, this primary document, Form 34A, was completely disregarded. Even if one were to argue, which at any rate is not the case here, that the verification was done against the original Forms 34A from all the polling stations, which had been manually ferried to the tallying center, this would still beg the question as to whether the scanned forms were and why, as to where the scanned forms were and why the manually transmitted ones arrived faster than the electronic ones. The failure by the first respondent to verify the results in consultation with the second respondent before the latter declared them, therefore, went against the expectations of Article 138(3)(c) of the Constitution, just as the failure to electronically and simultaneously transmit the results from all the polling stations to the National Tallying Center violated the provisions of Section 39(1)C of the Elections Act. These violations of the Constitution and the law call into serious doubt as to whether the said election can be said to have been a free expression of the will of the people as contemplated by Article 38 of our Constitution. It was further urged in court by a number of counsel for the first and second respondent that by disregarding Forms 34A and exclusively relying on Forms 34B, many of whose authenticity would later be called into question, in the tallying process, the said respondents were simply complying with the Court of Appeal's decision in Maina Kiai. We have already heard that we find little or nothing in this section, in this decision, that is in the Maina Kiai decision, to suggest that by deciding the way it did, the appellate court restrained or barred the first respondent from verifying the results before declaring them, or that it was relieving the former from the statutory duty of electronically transmitting the results. What the second respondent was barred from doing by the Court of Appeal and by the High Court was to vary, alter, or change the results relayed to the National Tallying Center from the polling stations and constituency tallying centers under the guise of verifying. But be that as it may, how spectacularly reassuring to the Kenyan people would it have been if the second respondent on that night of August 11th, 2017, had commenced the declaration of the results with these words: "Fellow Kenyans, the results I am about to declare are exclusively based on Forms 34B, which I have received from all the 290 constituency tallying centers countrywide. I have not verified these results against those tabulated on Forms 34A from all the 40,883 polling stations countrywide. This may sound strange, but I am simply doing this in compliance with the Court of Appeal's decision in the Maina Kiai case. This decision by the appellate court requires me to treat the results as tabulated by the various returning officers as final, and not to attempt to verify them against the electronically transmitted Forms 34A. You will therefore have to bear with me, as court orders must at all times be obeyed. However, all hope is not lost, since I have availed all the Forms 34A on our public portal. Any candidate, election observer, or member of the public is free to download these forms and compare the results thereon against the ones I am just about to declare. If such an exercise should reveal serious discrepancies, then one can petition the Supreme Court to scrutinize them and even annul them, since the Supreme Court has original and exclusive jurisdiction over such disputes. He failed to do the above, and apart from the duty to verify, the first respondent also has the responsibility to ensure that the system of voting, counting, tallying results is verifiable. This is in conformity with the Article 86 of the Constitution, which requires that, quote, at every election, the Independent Electoral and Boundaries Commission shall ensure that A, whatever voting method is used, the system is simple, accurate, verifiable, secure, accountable, and transparent. B, the votes cast are counted, tabulated, and the results announced promptly by the presiding officer at each polling station. C, the results from the polling stations are openly and accurately collated and promptly announced by the returning officer. And D, appropriate structures and mechanisms to eliminate electoral malpractice are put in place, including safekeeping of elections materials, unquote. This provision places upon the first respondent the onerous responsibility of devising and deploying election systems that the voter can understand. The first respondent must further be expected to provide access to crucial information that can enable either a candidate or a voter to cross-check the results declared by it with a view to determining the integrity and the accuracy thereof. In other words, the numbers must just add up. We note in the above regard that even where Parliament found it necessary to make provisions for a complementary system, it would not escape from the dictates of Article 86 of the Constitution, and hence Section 44A of the Elections Act provides, as I read, notwithstanding the provisions of Section 39 and Section 44, the Commission shall put in place a complementary mechanism for the identification of voters and transmission of election results that is simple, accurate, verifiable, secure, accountable, transparent, to ensure that the Commission complies with the provisions of Article 38 of the Constitution, unquote. When called upon to explain why all the Forms 34A had not been scanned, transmitted, and published on the online portal in line with Article 34 of the Elections Act, the first respondent, through counsel, alluded to some form of complementary mechanism. However, the description of such a mechanism did not appear to us to meet the yardsticks of verifiability inbuilt in the Constitution and Section 44A of the Elections Act. In their submissions, counsel for the respondents and the second interested party urged us not to annul the election on the basis of minor inadvertent errors. We entirely agree. We have already categorically acknowledged the fact that no election is perfect. Even the law recognizes this reality, but we find it difficult to categorize this violation of the law as minor, inadvertent errors. IEBC behaved as though the provisions of sections 39, 44, and 44A of the Elections Act did not exist. IEBC behaved as though the provisions of Article 88(5) of the Constitution, requiring it to, quote, exercise its powers and perform its functions in accordance with the Constitution and national legislation, quote, unquote, did not exist. IEBC failed to observe the mandatory provisions of Article 86 of the Constitution, requiring it to conduct the elections in a simple, accurate, verifiable, secure, accountable, transparent manner. Where is transparency or verifiability when IEBC, contrary to Articles 35 and 47 of our Constitution, was still, in the contumacious disobedience of this court's order, refuses to open its servers and logs for inspection? Having therefore carefully considered all the affidavit evidence and submissions of counsel for all the parties, we find and hold that the petitioners herein have discharged the legal burden of proving that the second respondent declared the final results for the election of the president before the first respondent had received all the results from Forms 34A from all the 40,883 polling stations, contrary to the Constitution and to the applicable law. We also find and hold that the second respondent declared the said results solely on the basis of Forms 34B, some of which were of dubious authenticity. We further find that the first respondent, in disregard of the provisions of Section 39(1)(c) of the Elections Act, either failed or neglected to electronically transmit in the prescribed form the tabulated results of an election of the president from many polling stations to the National Tallying Center. At this juncture, we must restate that no evidence has been placed before us to suggest that the process of voter registration, voter identification, manual voting, and vote counting were not conducted in accordance with the law. As a matter of fact, nobody disputes the fact that on 8th of August 2017, Kenyans turned out in large numbers, endured long hours on queues, and peacefully cast their votes. However, the system thereafter went opaquely awry, and whether or not the third respondent received a large number of votes becomes irrelevant, because read together, Sections 39(1)(c) and 83 of the Elections Act say otherwise. In passing only, we must also state that whereas the role of observers and their interim reports were heavily relied upon by the respondents as evidence that the electoral process was free and fair, the evidence before us points to the fact that hardly any of the observers interrogated the process beyond counting and tallying at the polling stations. The interim reports cannot therefore be used to authenticate the transmission and eventual declaration of results. For the above reasons, we find that the 2017 presidential election was not conducted in accordance with the principles laid down in the Constitution and the written law on elections, in that it was inter alia either transparent, neither transparent nor verifiable. On that ground alone, and on the basis of the interpretation we have given to Section 83 of the Elections Act, we have no choice but to nullify it.
I'll read and deal with the issues of irregularities and illegalities. And the issue we were dealing with is whether there were irregularities and illegalities committed in the conduct of the 2017 presidential election. And if the answer is in the affirmative, what was their impact, if any, on the integrity of the elections? While the impaneled election was conducted in violation of the relevant constitutional principles, the same was also alleged to have been fraught with irregularities and illegalities that rendered the result unverifiable and thus indeterminate. Illegalities refer to breach of the substance of specific law, while irregularities denote violation of specific regulations and administrative arrangements put in place. The petitioners, in that context, claim that the 8th August 2017 presidential election was conducted in an environment characterized by many systematic and systemic irregularities and illegalities that fundamentally compromised the integrity of the election, contrary to the principles laid down in the Constitution. The alleged irregularities and illegalities ranged from blatant non-compliance with the law to infractions of procedure, some of which were requirements by the laws and regulations relating to the election, while others had been put in place by the first respondent for the management of the elections. Illegalities. Allegations of undue influence, bribery, and voter intimidation. In addressing the above issue, at paragraph 37 of his supporting affidavit, Raila Odinga deposed that the third respondent, President Uhuru Kenyatta, brazenly violated Section 14 of the Elections Act. He must have meant Section 14 of the Elections Offences Act by inadvertently and by advertising and publishing in the print and electronic media as well as on billboards achievements of his government contrary to that section. We have quoted the section, I don't have to read it. This prohibition is clearly what Article 81E2 refers to as improper influence. In our view, the rationale behind this prohibition in the context of this case is that whatever achievements the current government may have made resulting from expenditure of public funds should not be taken advantage of by the government as a campaign tool. Section 14(1) and the subsection 2 of the Elections Offences Act provide that, except as authorized under this Act or any other written law, a candidate, referendum committee, or other person shall not use public resources for the purposes of campaigning during an election or a referendum. Subsection 2, no government shall publish any advertisements or achievements of respective government either in the print media, electronic media, or by way of banners or hoardings in public places during the election period, end of quote. In response to these allegations of improper influence and misuse of public resources, the third respondent submitted that the petitioners had not adduced evidence showing that the particulars of such a sponsorship, and that in any case, it is the mandate of the Presidential Delivery Unit to enhance accountability of a government to its citizens by availing information relating to the ongoing projects. We note in the above regard that the first petitioner has not attached any material evidence to support his proposition. That being the case, we are unable to make any determination on this issue of lack of material particulars. Furthermore, the third respondent submitted that the question whether he was allegedly sponsoring the advertisement of the government's achievement in the print and electronic media is pending at the High Court in the case of Apollo Mboya versus the Attorney General and others, and Jack Munjalo and others versus the Attorney General under the Independent Electoral and Boundaries Commission. The petitioners did not contest this averment, and in this regard, we have previously held that we can not adjudicate on an issue which is still the subject matter of judicial determination at the High Court. Reference in this respect is made to the advisory opinion this court gave in the case of, in the matter of Independent Electoral and Boundaries Commission in 2011. I don't have to read that, the quotation which states that the Supreme Court cannot adjudicate on a matter which is square and pending before the High Court. Further to the above finding, we also note that the petitioner's further contention that the first respondent failed to act on the third respondent's alleged violation of the law by his misuse of public resources. In response, the second respondent stated that he wrote a letter on the 21st of June 2017 informing the Director of Public Prosecutions about the alleged misconduct of the third respondent. The said letter is attached to the affidavit sworn by Wafula Chebukati, the details of which letter we have quoted. We note further that from considering the contents of the above letter, and contrary to the submissions by the first and second respondents, the above letter did not apply to the holder of the office of presidency, in which category the third respondent falls. Furthermore, we note that Section 14.3 of the Election Offences Act, which provides for the Commission's enforcement powers, does not apply to the person holding the office of president. The section we have quoted there in verbatim. Having that in mind and fortified by our observation that the interpretation of Section 14 of the Elections Offences Act is a live matter before the High Court, we are unable to address our minds into an allegation that touches on this section. That is the end of that allegation. We are unable to deal with that in the absence of any evidence. We further note in paragraph 34 of his said affidavit that Raila also claimed that while campaigning in Makueni County, on 2nd August 2017, President Uhuru Kenyatta threatened chiefs in the area with dire consequences if he won for failure to campaign for him. That such an action also goes against Article 81E2 of the Constitution, which outlaws intimidation in the electioneering process. In proof of this assertion, the petitioners have attached transcripts of video evidence in the supplementary affidavit sworn by Ogila Karani, detailing the alleged offending words spoken by the third respondent. In response, the third respondent relies on an affidavit sworn by Dr. Karanja Kibicho, who affirms that the Principal Secretary, Ministry of Interior and the Coordination of National Government, he received information to the effect that some chiefs in Makueni whose names also were provided in the said affidavit, were unlawfully using their positions, and the government issued motorcycles to campaign for the petitioners. It therefore reported the same to the third respondent, who warned the chiefs in that area not to take any political position nor use public resources to campaign for anyone. According to Dr. Kibicho, it is against that background that the third respondent uttered the words, uttered the remarks now impugned by the petitioners. In the above context, Section 10 of the Election Offences Act is also relevant. We have quoted the full section. What then is the meaning of undue influence in the context of electoral malpractices, and particularly as used under Section 10 above? In India, the meaning of undue influence is found in Section 171C of the Penal Code, which defines the offense of undue influence in that country. Though the wording of the Indian Penal Code quoted above is materially different from Section 10 of the Elections Act, the meaning injected into the above legal provision shows its applicability to the Kenyan context. The Supreme Court of India, in the consolidated case of Charan Lal versus Glani and others, thus explicitly stated that the test was whether there was an interference or an attempted interference with the free exercise of the electoral right. Similarly, Section 10 above, whose marginal note is undue influence, forbids any impediment of a person's exercise of the electoral right. In India, the electoral right of an elector is defined under Section 171AB of the Indian Penal Code as the right of a person to stand or not to stand, or to withdraw from being a candidate, or to vote, or refrain from voting at an election. This is comparable with the Article 38(3) of our Constitution, which confers certain political rights on every citizen without any restrictions, including the right to vote by a secret ballot in an election. The above case of India laid down distinction between mere canvassing for votes and the acts of undue influence. In so doing, the Supreme Court of India pronounced itself in the following manner, and I quote, "If the mere act of canvassing in favor of one candidate as against another were to amount to undue influence, the very process of democratic election shall have been stifled, because the right to canvass support for a candidate is as much important as the right to vote for a candidate of one's choice. Therefore, in order that the offense of undue influence can be said to have been made out within the meaning of Section 171C of the Penal Code, something more than the mere act of canvassing for a candidate must be shown to have been done by the offender. That something more may, for example, be in the nature of a threat, of an injury to a candidate or a voter, as is stated in the subsection 2A of Section 171C of the Penal Code, or may consist of inducing a belief of divine displeasure in the mind of a candidate or a voter, as is stated in subsection 2. The act allegedly as constituting undue influence must be in the nature of pressure or tyranny on the mind of the candidate or the voter. It is not possible to enumerate exhaustively the diverse categories of acts which fall within the definition of undue influence. It is enough for our purpose to say that one thing that of one thing there can be no doubt: the mere act of canvassing for a candidate cannot amount to undue influence within the meaning of Section 171C of the Penal Code, end of quote. The Supreme Court of India also held that the language used in the definition of undue influence implies that an offense of undue influence would be held to have been committed if the elector, having made up his mind to cast a vote for a particular candidate, does not do so because of the act of the offender. And this can only be if he is under the threat or fear of some adverse consequences. Wherever any threat of adverse consequences is given, it will tend to divert the elector from freely exercising his electoral right by voting for the candidate chosen by him for the purpose. But in cases where against the law for a public officer to openly take conclusive finding on this issue. Further, we note that from the evidence of Dr. Kibicho explaining the context within which the third respondent uttered the said words remain undisputed. Consequently, after carefully considering the evidence before us, we hold that the petitioners have not proved their case on this issue as required, the required standard. The petitioners further alleged that the third respondent and the deputy president, being contestants in the presidential election, are guilty of corruptly influencing voters in the lead up to the 8th August 2017 general election by paying reparations to victims of 2007 post-election violence in various parts of the country, and used the platform to canvass for votes for personal political gain in the said electoral areas, contrary to the Election Offences Act. In proof of this assertion, the petitioners rely on the affidavit of Ms. Ogla Karani, who attaches a transcription of the third respondent's speech during his tour of Kisii and Nyamira counties during the campaign period. In response, the third respondent relied on the affidavit sworn by Dr. Kibicho, aforesaid, who stated that there is a National Consultative Coordination Committee which is tasked with the obligation to manage the internally displaced persons' affairs on behalf of the government. That any such sums are approved by Parliament and released by the committee into the beneficiary's account, and the third respondent is not involved in that matter at all. We have perused the attached video transcript which is the form of interview conducted by one of the local news reporting station. We note that the transcript does not contain a satisfactory basis or convincing evidence to the effect that the third respondent acted in any inappropriate manner with regard to the release of the funds for the IDPs. The first petitioner's further complaint on illegalities is that the President Uhuru Kenyatta engaged cabinet secretaries who openly abused their position and used state resources in actively soliciting votes for him. Referring to Article 152(4)(a) of the Constitution, the petitioner submitted that that every cabinet secretary swears to or affirms to have obedience to the Constitution of Kenya and ought therefore to be impartial in political contests as is required under the Constitution. In a supplementary affidavit sworn by Olga Karani, the petitioners list various incidences in which they claim that the cabinet secretaries campaigned for the third respondent. At paragraph 10 of the said affidavit, the deponent affirms that Joe Mucheru, the cabinet secretary in charge of information, communication and technology, at an interview conducted by a local television station, stated that he was at liberty to campaign for the third respondent because no law barred him from doing so. Other cabinet secretaries also mentioned in Karani's affidavit include Eugene Wamarwa, Mwangi Kiunjuri, and Najib Balala. The petitioners in their submissions on these issues brought to the attention of the court what they consider to be an inconsistency in the law, and in this respect, they urged the court to declare Section 23 of the Leadership and Integrity Act to be unconstitutional. In that regard, we have quoted the full section. The petitioner submitted that since cabinet secretaries are state officers, they ought to be impartial, but that Section 23 above gives them leeway for impartiality. The third respondent contested that submission and urges the court to disregard it, since the issue of unconstitutionality was not pleaded in the petition, but was only introduced as an argument in the petitioner's oral submissions. The third respondent also urges that the Supreme Court, in exercise of its exclusive original jurisdiction, cannot adjudicate on the unconstitutionality of an act of Parliament, since that is a matter within the domain of the High Court in exercise of its jurisdiction under Article 165(3)(d) of the Constitution. In addressing the above issue, we note that in rendering our advisory opinion, we also say that we cannot deal with a matter. No, I will read that again. In addressing the above issue, we note that in rendering an advisory opinion in the matter of the Interim Independent Electoral Commission, this court stated that paragraph 43, and I quote, "Quite clearly the High Court has been entrusted with the mandate to interpret the Constitution. This empowerment by itself, however, does not confer upon the High Court an exclusive jurisdiction, for by the appellate process, both the Court of Appeal and the Supreme Court are equally empowered to interpret the Constitution, certainly in respect of matters resolved at the first instance by the High Court. And while the advisory opinion jurisdiction is exclusively entrusted to the Supreme Court, the Constitution does not provide that this court, while rendering an opinion, may not interpret the Constitution. Indeed, interpretation of the Constitution stands to be conducted for different purposes and at different stages by a vast array of constitutional organs. So, for instance, the State Law Office, in advising government ministries, is entitled to interpret the Constitution as may be necessary, and the several independent commissions under the Constitution are similarly entitled to interpret the Constitution as part of the performance of their respective mandates. The Supreme Court, too, for purposes of rendering an advisory opinion, may take its position as guided by its own interpretation of the Constitution. Only where litigation takes place entailing issues of constitutional interpretation must the matter come in the first place before the High Court, with the effect that interpretation of the Constitution by both the Court of Appeal and the Supreme Court will have been limited to the appellate process. End of quote. It is not in doubt, therefore, that the Supreme Court may, in exercise of its jurisdiction, such as this, interpret the Constitution, and in so doing, where the need requires, declare an offending provision of the law to be unconstitutional. Such is a natural consequence of any legal reasoning if the court were to maintain its fidelity to the law. Indeed, in the case of S.K. Macharia versus KCB, the court declared Section 14 of the Supreme Court Act to be unconstitutional. However, the present scenario is peculiar in the sense that the petitioners did not, at the very first instance, through their pleadings, indicate their intentions to declare Section 23 of the Section 23 unconstitutional. The rule of thumb has always been that parties must be bound by their pleadings, and especially in a case such as this, where the petitioner is asking the court to address its mind to the possible unconstitutionality of a legal provision. For proper consideration, therefore, and especially in order to do justice to both the parties and the greater public interest, we cannot afford to lock our eyes to the disadvantage placed upon the third respondent, especially who had no benefit to bring his mind, to bring his thoughts into this cause. In the circumstances, we are unable to find that Section 23 is unconstitutional. Let the matter be addressed in the right proceedings, in the right circumstances. Irregularities. Apart from the outright non-compliance with the electoral law, the petitioners also claimed that the presidential election was marred by many irregularities and the cumulative effect of which fundamentally and negatively impacted on the integrity of the election. The most serious of the irregularities alleged by the petitioners was that many of the prescribed forms 34A, 34B, and 34C that were used in the election had no security features. Other such forms had different layouts and security features. I don't have to read all that. We have considered the security features. The prominent one coming out of this is that some of these forms did not have those security features, whereas the information we were given was that they were all printed by the same printer and they should have had those security features. We disagree with the council that this is not in the Act and that it was as a result of abundance of caution taken by IEBC. If that was the case, then all the forms should have the features, the security features that IEBC itself devised, and there is no reasonable explanation given why some should not have and some should have. That is the conclusion we have reached. So we have also considered that there are some, the report which was tabled, the scrutiny report, shows that some forms that were availed were carbon copies, others were the original forms 34A, but did not bear those, the IBC stamp. Other forms were stamped and scanned, while others were not, and they were photocopies. We have considered all those. The report that was availed But what comes out is that from the report, the scrutiny report indicates that out of a random examination of 4,299 forms 34A, 481 were carbon copies, but they were signed. 157 were carbon copies which were not stamped. 269 were original copies that were not signed. 26 of the forms were stamped. And some were not signed by the agents as required, and there was no explanation given as to why the agents did not sign, or they were, why they were not given to sign. Submitting on these findings, Mr. Orengo, for the petitioners, contended that the report had proved beyond reasonable doubt that the election process was shambolic. According to counsel, from 34C, which was used to announce the presidential results, had no security features, and hence the authenticity of the results, as announced in Form 34C, could not be guaranteed. Counsel further contended that in totality, the number of votes affected is more than 90 constituencies. In more than 90 constituencies, as a consequence of these irregularities, could be as high as 5 million. Counsel submitted that a random sampling of the Forms 34A depicts numerous irregularities, those ones which I have already enumerated. In response, the respondents were categorical that most of the forms met the standard required features. They stated that the petitioners had failed to demonstrate that any of the figures in the forms were inconsistent with what was announced. Further, that the format of the forms was undisturbed. I'm trying to skip the parts which are details of which I've explained. As we have noted that out of 291 forms, 56 from that random sample, 56 did not have the watermark features, while that one did not bear the serial numbers. And a further 5 were not signed at all. And the 2 were only stamped by the returning officers, but not, were stamped by the returning officers, but not signed. In addition, a further 32 forms were not signed by the agents. The above indices are a single out, since they are indices where accountability and transparency of the forms are in question. The court also notes that in her affidavit, Immaculate Kasaiti, director of the first respondent, stated, and we have quoted in extenso the averments of Kasaiti, where she categorically states that all these forms had the features that were given by IEBC to the printers. The above categorical statement differs completely with the abundance of caution submission by Mr. Muite, Senior Counsel, that it is not in the law and this was just optional for IBC to make. In the above context, we now turn to examine the applicable statutory provisions in this regard. As pointed out by the petitioners, there is a reasonable expectation that all forms ought to be in a standard form and format, and though there is no specific provision requiring the forms to have watermarks and serial numbers as security features, there is no plausible explanation for this discrepancy, more so when Immaculate Kasaiti deposed that all of them had those features. There is another set of discrepancies relating to 31 forms not being signed by the agents, 103 forms where the handover report was not signed against the regulations that require that. It is clear that the purpose of including the requirements for indicating the number of forms received by various officers was to ensure accountability and transparency. It is therefore unfortunate that out of the random sample of 4,299 forms that 4A examined, a total of 189 forms had not been filled in the handover section, whereas 287 forms had not been filled in the takeover section. Such kinds of scenarios raises the question as to the kind of verification done, if at all, by the chairperson of the commission. As forms 34A, the sampled 4,299 forms revealed that 481 of them were carbon copies, 269 were not stamped, 257 of the carbon copies were not signed, 11 forms had no watermarks, 46 of the photocopies were not signed, and 58 others not stamped. Considering the sample size, it is apparent that the discrepancies were widespread. Did these discrepancies affect the integrity of the elections? I now consider the impact of the irregularities on the integrity of the election. Counsel for the respondents urged the court to dismiss the petition, as this would preserve the will of the people who turned out in large numbers to vote for their preferred candidates. Our attention in that regard was drawn to the provisions of Article 38 of the Constitution, which is the embodiment of the political rights of the citizen. It was variously submitted that the elections are about numbers and that they are about who gets the largest number of votes. Such irregularities, as complained of by the petitioners, counsel submitted, could not in themselves overturn the sovereign will of the people. Further, in the quantitative discrepancies, if the quantitative discrepancies are so negligible, in this case, allegedly slightly over 20,000 votes, they should not affect the election. For in the words of Professor Lumumba, counsel for the second respondent, of small things, the law has no remedy. On the other hand, the counsel for the petitioners urged the court to look at the elections as a whole, as a process rather than an event, to look at not just the numbers, but the entire conduct of the election. Mr. Mwangi, counsel for the petitioners, went as far as to submit that the elections are not political processes. I'll read that again. Mr. Mwangi, counsel for the petitioners, went as far as to submit that the elections are not a political process, but a legal one. That the court should concentrate on examining the legal process in the conduct of elections as opposed to the political process. It is our view, however, that elections are all these. None of the factors highlighted by the parties can be viewed in isolation. For by doing so, we run the risk of cannibalizing a sovereign process. Elections are the surest way through which people express their sovereignty. Our Constitution is founded upon the immutable principle of the sovereign will of the people. The fact that it is the people and they alone in whom all power resides, be moral, political, or legal, and so they exercise such a power either directly or through representatives whom they democratically elect in free, fair, transparent, and credible elections. Therefore, whether it be about numbers, whether it be about laws, whether it be about processes, an election must at the end of the day be a true reflection of the will of the people as decreed by the Constitution through its hallowed principles of transparency, credibility, verifiability, accountability, accuracy, and efficiency. It is in this spirit that one must read Article 38 of the Constitution, for it provides in the area that every citizen is free to make political choices which include the right to free, fair, and regular elections based on a universal suffrage and the free expression of the will of the electors. This mother principle must be read and applied together with Articles 81 and 86 of the Constitution. For to read Article 38 in a vacuum and disregard other enabling principles, laws, and practices attendant to elections is to nurture a mirage and an illusion of free will, hence a stillborn democracy. Of such an enterprise, this court must be wary. It is also against this background that we consider the impact of irregularities that characterized the presidential election. At the outset, we must re-emphasize the fact that not every irregularity, not every infraction of the law is enough to nullify an election. Were it to be so, there would be hardly an election in this country, if not in the world, that would withstand judicial scrutiny. The correct approach, therefore, is for a court of law to not only determine whether the election was characterized by irregularities, but whether those irregularities were of such a nature or of such a magnitude as to have either affected the result of the election or to have negatively impacted the integrity of the election, that no reasonable tribunal would uphold it. In view of the interpretation of Section 83 of the Elections Act that we have rendered, this inquiry about the effect of electoral irregularities and malpractices becomes only necessary where an election court has concluded that non-compliance with the law relating to the election did not offend the principles laid down in the Constitution or in that law. But even where a court has concluded that the election was not conducted in accordance with the principles laid down in the Constitution and the applicable electoral laws, it is good judicial practice for the court to still inquire into the potential effect of any irregularities that may have been noted upon an election. This helps to put the agencies charged with the responsibility of conducting elections on notice. In the impending presidential election, one of the most glaring irregularities that came to the fore was the deployment by the first respondent of prescribed forms that either lacked or had different security features. The first respondent had submitted by way of affidavit and in open court that out of abundance of caution, it had embedded into the prescribed form such impenetrable security features that it was nigh impossible for anyone to tamper with them. The court was also minded that this was done despite being not a requirement of the law. However, the scrutiny order and the scrutiny order and conducted by the court brought to the fore momentous disclosures. What is this court, for example, to make of the fact that 290 out of 290 Forms 34B that were used to declare the final results, 56 of them had no security features. What had the security features touted by the first respondent disappeared to? Where had they disappeared to? Could these critical documents be still considered genuine? If not, then could they have been forgeries introduced in the vote tabulation process? If so, with what impact to the numbers? If they were forgeries, who introduced them into the system? If they were genuine, why were they different from the others? We were disturbed by the fact that after an investment of taxpayers' money running into billions of shillings for the printing of election materials, the court would be left to ask itself basic fundamental questions regarding the security of voter tabulation forms. Form 34C, which was the instrument in which the final result was recorded and declared by the public, was itself not free from doubts of authenticity. This form, as crucial as it was, bore neither watermark nor serial number. It was instead certified as being a true copy of the original. Of the 4,229 forms 34A that was scrutinized, many were not stamped, yet others were not signed. I think that I've already stated that. Why would a returning officer, or for that matter the presiding officer, fail to or neglect to append his signature to a document whose contents he or she generated? Isn't the appending of the signature to form a bearing that the tabulated results, the last solemn act of assurance to the voter by such an officer that stands by the numbers on the form? Where do all these inexplicable irregularities that go to the very heart of electoral integrity leave this election? It is true that where the quantitative difference in numbers is negligible, the court, as we were urged, should not disturb the election. But what if the numbers are themselves a product not of the expression of the free and the sovereign will of the people, but of many unanswered questions with which we are faced? In such a critical process as the election of the president, isn't quality just as important as quantity? In the face of all these troubling questions, would this court, even in the absence of a finding of violations of the Constitution and the law, have confidence to lend legitimacy to this election? Would an election observer, having given clean bill of health to this election on the basis of what he or she saw on the voting day, stand by his or her verdict when confronted with these imponderables? It is to the Kenyan voter that a man or woman who wakes up at 3 a.m. on voting day, carrying with him or her the promise of the Constitution to brave the vicissitudes of nature in order to cast his or her vote, that we must leave that judgment. In concluding this aspect of the petition, it is our finding that the illegalities and the irregularities committed by the first respondent were of such a substantial nature that no court, properly applying its mind to the evidence and the law as well as the administrative arrangements put in place by IEBC, can in good conscience declare that they do not matter and that the will of the people was expressed nonetheless. We have shown in this judgment that our electoral law was amended to ensure that in substance and form, the electoral process and the results are simple yet accurate and verifiable. The presidential election of 8 August 2017 did not meet the simple test, and we are unable to validate it, the result notwithstanding. I'm skipping the orders that have been sought. In conclusion, in this judgment, we have settled the law as regards Section 83 of the Elections Act, and its applicability to the presidential election. We have shown that, contrary to the popular view, the results of an election in terms of numbers can be overturned if a petitioner can prove that the election was not conducted in compliance with the principles laid down in the Constitution and the applicable electoral law. Never was the word "or" been given such a powerful meaning. Why did we do this? We did so because that's the word "or" in Section 83 of the Elections Act. We did it so because, as judges, we have taken an oath, as advocates first and as judges later. In these two oaths, the fundamental words are a fidelity to the Constitution without fear or favor. The constitutional principles that we have upheld in this judgment were embedded and became a critical part of our electoral law. The legislature, in its wisdom, chose the words in Section 83 of the Elections Act, and in keeping to our oath, we cannot, to placate any side of the political divide, alter, amend, read into, or in any way affect the meaning to be attributed to that section. As for the IEBC, all we are saying is that the constitutional mandate placed upon it is a heavy yet noble one. In conducting the fresh election consequent upon our orders, and indeed in conducting any future election, IEBC must do so in conformity with the Constitution and the law. For what is the need of having a constitution if it is not respected? Having taken note of Mr. Nyamudi's submissions, which appeared to suggest that IEBC had put in place a complementary system for transmission of results, a system that was neither simple nor known to the petitioners, we hereby direct that in conducting the fresh election, IEBC must put in place a complementary system that accords with the provisions of Section 44A of the Elections Act. It goes without saying that such a system, as held by the High Court and affirmed by the Court of Appeal in the case of National Super Alliance versus Independent Electoral Commission, only comes into play when the technology fails. In the 2013 Raila Odinga case, the court stated, and I quote, "It should not be for the court to determine who comes to occupy the presidential office, save that this court, as the ultimate judicial forum entrusted under the Supreme Court Act, with the obligation to assert the supremacy of the Constitution and the sovereignty of the people of Kenya, must safeguard the electoral process and ensure that the individuals succeed to the power in the presidential office only in compliance with the law regarding the elections." We reiterate those words in this petition, and for as long as the Constitution of Kenya has the provisions granting this court the mandate to overturn a presidential election in appropriate circumstances, it will do so because the people of Kenya, in the preamble to the Constitution adopted, enacted and gave unto themselves the Constitution, and for themselves and the future generations. It is also our view that the greatness of a nation lies not in the mighty of its armies, important as that may be, not in the largeness of its economy, important as that may also be. The greatness of a nation lies in its fidelity to the Constitution and the strict adherence to the rule of law, and above all, the fear of God. The rule of law ensures that society is governed on the basis of the rules and not the mighty of force. It provides a framework for orderly and objective relations between citizens in a country. In Kenya, in the Kenyan context, this is underpinned in the Constitution. And as Surabaj, a former Attorney General of India, wrote, "The rule of law is the heritage of all mankind. and a salutary reminder that wherever law ends, tyranny begins. Cast the rule of law to the dogs, and as Luton once observed, the government becomes an euphemistic government of men. He adds, history has shown, sadly I might add, that even the best rulers have fallen prey to the cruel desires of naked power, and that reliance on the goodwill of politicians is often a risky act of good faith. End of the quote. The moment we ignore our constitution that the Kenyans fought for decades, we lose it. We further note that elections world over are competitive features. Presidents in many parts of the world, and especially in Africa, wield a lot of power. The influence that comes with that office makes it very attractive. That influence cascades down through all the elective positions to the lowest. Candidates and political parties often do anything to be elected. Besides the candidates, the electorate themselves, hoping for an improved standard of living, get equally agitated. All these factors make elections at every level extremely high-pressure events. If these are mismanaged, or candidates do not respect the rule of law, if the average citizen, political parties, and even candidates themselves do not perceive them as free and fair, elections can and have led to instability in some countries. Examples of such cases are abound, but we don't need to look far. We know what we went through in 2007, post-election skirmishes that left over 1,000 people dead and over 5,000 others displaced and drove the country almost to the brink of precipice, not to mention the economic crisis that was thereby wrought. In the circumstances and in answer to the respondents' harp on the numbers, we can do no better than to quote the words of the Indian Court of Appeal, where the judge says, there is no denying the fact that the election of a successful candidate is not likely to be interfered with by the courts. The courts generally lean in favor of the returned candidate and place the onus of proof on the person challenging the end result of an electoral contest. That approach is more in the nature of a rule of practice than a rule of law, and should not be unduly stretched beyond a limit. We say so because while it is important to respect the popular verdict and the courts ought to be slow in upsetting the same, it is equally important to maintain the purity of the electoral process. An election which is vitiated by reason of corrupt practices, illegalities, and irregularities cannot obviously be recognized and respected as the decision of the majority of the electorate. The courts are, therefore, duty-bound to examine the allegations wherever the same are raised within the framework of the statute, without being unduly hyper-technical in its approach, and without being oblivious to the ground realities. Experience has shown that the electoral process is, despite several safeguards taken by the statutory authorities concerned, often vitiated by use of means, factors, and considerations that are specifically forbidden by the law. What of the argument that this court should not subvert the will of the people? This court is one of those to whom the sovereign power has been delegated under Article 1(3)(c) of the Constitution. All its power, including the invalidating of the presidential election, is not self-given nor forcibly taken, but is donated by the people of Kenya. To dishonestly exercise that delegated power and to close our eyes to the constitutional violations would be a dereliction of duty, and we refuse to accept the invitation to do so, however popular the invitation may seem. Therefore, therefore, however burdensome, but the majesty of the Constitution reverberates across the lengths and breadths of our motherland. Let it bubble from our rivers and oceans. Let it boomerang from our hills and mountains. Let it serenade our households from the treetops. Let it sprout from our institutions of learning. Let it toll from our sanctrums of prayer. And to those we bear the responsibility of leadership, let it be a constant irritant. Have we, in executing our mandate, lowered the threshold for proof in presidential elections? Have we made it easy to overturn the popular will of the people? We do not think so. No election is perfect, and the technology is not perfect either. However, where there is a context in which two houses of parliament jointly prepare a technological roadmap for conduct of elections and insert a clear and simple technological process in Section 39(1)(c) of the Elections Act, with the sole aim of ensuring a verifiable transmission and the declaration of the result system, how can this court close its eyes to an obvious and near total negation of the transparent process? In keeping with our pronouncement regarding the burden and the standard of proof in election petitions, we are therefore satisfied that the petitioners have discharged the legal burden of proof as to squarely shift it to the first and second respondent. We are also of the firm view that having so shifted the burden has not in turn been discharged by the first and second respondents as to raise substantial doubt in regard to the petitioner's case. For the above reasons, let this judgment then be read in the proper context. The electoral system in Kenya today was designed to be simple and verifiable. Between the 8th of August 2017 and the 11th of August 2017, it cannot be said to have been so. The petition before us was, however, simple and to the point. It was obvious to us that IEBC misunderstood it, hence it jumbled up responses and submissions. Our judgment is also simple and, in our view, clear and understandable. It ought to lead IEBC to a soul searching and to go back to the drawing board. If not, this court, wherever called upon to adjudicate on a similar dispute, will reach the same decision if the anomalies remain the same, irrespective of who the aspirants may be. Consistency and fidelity to the Constitution is an unwavering commitment this court makes. One of the other peripheral but important matter requires our attention: the time frame for hearing and the determination of presidential election petition in Kenya. The court is able to bear all manner of criticism, but one would be extremely unfair. Alleged inability to deliver on time. Where is the time? Between the decision in 2013 and the present petition, it was a matter of agreement across Kenya that 14 days is not enough for parties and the court to fully deliver on their respective mandates. Not because they cannot, in fact they all have, but because there may be the need to conduct exercises such as a recount of votes or a scrutiny which require substantial amount of time. Yet the legislature ignored pleas to rethink the time frame. It is time they did so. The reasons for doing so are obvious and need no extrapolation here. In concluding, we must express our profound gratitude to Council who appeared before us for their submissions that assisted us in reaching this decision. Before we read the final orders, I would now allow my colleagues to read their dissents. And I'm requested to start with Justice Ojwang. Thank you.
As so proximate to the moment of delivery of the Supreme Court's decision in this pivotal case, did I learn that I fell on the minority side. By the Constitution, the timeline for hearing and determination was below a fortnight, and so full versions of the judgment had to come later. My summarized dissent thus grasped only the compelling elements of the case. Today, I have the opportunity to set out my opinion in detail. The question before the court was whether the presidential election conducted under one and the same electoral process with 5 other sets of election for the Senate, National Assembly, county governors, women's representatives, and county assemblies had been so compromised by operational irregularity and illegality as to compelling attract orders of government. I learned that the majority on the bench had come to the unreserved resolution that the presidential election was a nullity and that the electorate must return to the polls. The position is summarized in orders which have been given on the majority side, indicating precisely what was decided. Thus, vital issues turning upon the democratic principle, issues of the terms and essence of the Constitution, of the statute law, and of the judicial mandate in the interpretation and crystallization of functional dimensions of the legal process had been so cursorily dispatched, maybe in answer to policy objects, or to political persuasions, or to other general social calls. For me, as an experienced lawyer and judge, but more particularly as a dedicated legal scholar, such an approach to contentious matters did short shrift to the firm and principled normative configuration of the law and the legal process, elements which alone would temper the motions of the social and political order and ensure that the mechanisms of governance remain attuned to the ideals of civilized process. I will, in this judgment, examine the foregoing dimensions of law with greater focus after adverting to the pertinent issues and evidence in the whole course. Now, there was the main course brought by the petitioners, and there was the prelude. The petitioners were the presidential and deputy presidential candidates of the National Super Alliance coalition of parties and were running on the Orange Democratic Movement Party and the Wiper Democratic Movement Party tickets, respectively. The first respondent is the Independent Electoral and Boundaries Commission, an independent agency established under Article 88, as read with Articles 248 and 249 of the Constitution of Kenya, and the Independent Electoral and Boundaries Commission Act 2011. The first respondent bears the mandate of conducting and or supervising referenda and elections for any elective body or office established under the Constitution, as well as any other elections provided for under the Elections Act. The second respondent is the chairperson of the first respondent and bears the mandate under Article 138(10) of the Constitution to declare the outcome of the presidential election and to deliver written notification of the same to the Chief Justice and to the incumbent president. The third respondent is the incumbent president, who was the candidate of the Jubilee Party and who was declared the winner in the elections on the 11th of August 2017. The petitioners are aggrieved with the mode of conduct of the presidential election of the 8th of August 2017. They contend that the said election was conducted, administered, and managed improperly by the first respondent, and that such mismanagement was deliberate and systematic, and having the effect that there was failure of compliance with the governing principles prescribed under Articles 1, 2, 4, 10, 38, 81, 82, 86, 88, 138, 140, 163, and 249 of the Constitution, with the Elections Act, with the regulations made thereunder, with the Electoral Code of Conduct, and with other relevant provisions of the law. The petitioners call for the invalidation of the second respondent's declaration of the third respondent as a duly elected candidate. The prelude to the main course is marked by a set of preliminary applications. I don't have to go to those. I've listed them, so you will be able to read them for yourselves. It was the petitioner's contention that during the presidential election, being part of the general election of the 8th of August 2017, certain management improprieties came to pass, which affected the registration of voters, the votes cast, the vote count. One of the allegations related to the category of votes described as rejected votes, said to have constituted 2.6% of the total votes cast. The issue being raised in this regard came alongside a contention that an earlier decision of the Supreme Court of 2013 should be reversed, insofar as the court had in that case held that spoiled votes are not to be taken into account in computing the 50% plus one vote strength threshold for determining the winner in a presidential election. Such a claim is founded upon a desired legal yardstick, rather than on the prescribed and operative law. The petitioners contended that the Supreme Court, in the earlier case, had improperly arrived at its legal threshold because it had been influenced by a dissenting opinion in a comparative case citation noted by this Supreme Court, which by Kenya's Constitution, Article 163(7), is the ultimate judicial authority, and, quote, all courts other than the Supreme Court are bound, end of quote, by its decision. The petitioners were invoking the case from Seychelles, Popular Democratic Movement Against the Electoral Commission of 2011. They were urging that the majority stand in that case should determine this Supreme Court's position as regards spoiled votes in the electoral process, and that in that context there was an impropriety in the presidential election vote count following the election of the 8th of August 2017. The petitioners contended that the conduct of the presidential election of the 8th of August 2017 had contravened the principle of free and fair election under Article 81(e) of the Constitution, as read with Section 39 of the Elections Act and the applicable regulations. The burden of the petitioner's case lies on the process of relaying and transmitting voting records from polling stations to constituency tallying centers and the National Tallying Center. They questioned this process as falling short of the standards on simplicity, accuracy, verifiability, security, accountability, transparency, promptitude. They contended that such shortcomings had compromised the principle of free and fair elections in terms of Article 81E, subparagraph 4 and 5 of the Constitution. The petitioners attributed impropriety to the electoral process on a plurality of grounds, such as 1, that the data and information recorded in Forms 34A at the individual polling stations had not been accurately and transparently entered into the electronic kits at the individual polling stations. 2, that there had been non-compliance with the requirement that kits be accompanied by an electronic image of the prescribed forms as these were transmitted to the National Tallying Center, and this was in contravention of Regulation 87.3 of the Elections General Regulations. 3, that the first respondent had predetermined the results of the presidential election and was therefore not impartial, neutral, and accountable as required by Article 81E5 of the Constitution. The declared results were not verified in more than 10,000 polling stations, and the data entered in the electronic kits was not consistent with the information in Forms 34A. That the information in Forms 34A was not consistent with that in Forms 34B, and the figures were not accurate and verifiable. That the computation and tabulation of the results in a significant number of Forms 34B was not accurate, verifiable, and internally consistent. That the results recorded in the first respondents' Forms 34B were materially different from those relayed and relayed again as at the time of filing on the website. That the first respondent had espoused a false narrative, a national psyche, as the stage for stealing the election on behalf of the third respondent by allowing the electronic media and the news channels to relay and continue relaying its results data which lacked a legal or factual basis, and that at the time of declaration of election result, the first respondent was not in possession of Forms 34B and did not publicly display the same for verification. The petitioners contended that the presidential election was not impartial, not neutral, not efficient, not accurate, not accountable, as required under Article 81E5 of the Constitution, as read with Sections 39, 44, 44A of the Elections Act and regulations made thereunder, and Section 25 of the IEBC Act, and that there were instances in which vote count had been distorted, manipulated, or inflated in favor of the third respondent. The petitioners asserted that it was impossible to determine who had won the presidential election or whether the threshold for winning the election was met. The petitioners contended that there had been a deliberate failure in the operational transparency and that the respondent had disregarded the decision of the Court of Appeal in Independent Electoral and Boundaries Commission against Maina Kiai, case number 105 of 2017, by failing to electronically collate, tally, and transmit accurate results, and by declaring results by county rather than by polling stations. The petitioners contended that the first respondent had allowed the transmission and display of unverified provisional results contrary to law, that the first respondent had also posted contradictory results in Forms 34A and 34B, and that there were internal contradictions in Forms 34A. They contended that the first respondent had declared final results on the 11th of August 2017, even before receiving results from all polling stations, and that allowed more than 14,000 defective forms from polling stations, with the outcome of distorting more than 7 million votes. The petitioners contended that the first respondent had colluded with the third respondent to eject their legitimate agents from various polling stations in Central and Rift Valley regions. On the basis of such allegations, the petitioners contended that the first respondent had abdicated its responsibility for ensuring a transparent and an impartial voting process, apart from corrupting the process of transmission of results. The petitioners contended that the first respondent had failed to adhere to the Constitution, rule of law, court orders and decisions, and that such a condition rendered the process of the presidential election, the transmission of results, and the final outcome a nullity, as it lacked integrity, fairness, transparency. The petitioners contended that there had been a violation of Article 86 of the Constitution and that the votes cast in a significant number of polling stations were not counted, tabulated, and accurately collected as required under Article 86 B and C of the Constitution, as read with the Elections Act. They contended that the results recorded in Forms 34A differed from the results shown in the first respondent's Forms 34B and displayed in the first respondent's website. And they asserted that the first respondent's Forms 34B were inaccurate, bearing statistical manipulation to favor the third respondent. The petitioners contended that the first respondent had acted contrary to the terms of Article 38, 81, 86 of the Constitution, as read with Sections 39(1)(c) and 44 of the Elections Act and the regulations thereunder, as well as Section 25 of the IEBC Act. The petitioners contended that contrary to Regulation 7(1)(c) of the Elections General Regulations, the first respondent had fraudulently established secret and ungazetted polling stations wherefrom vote count results were added to the final tally, thereby undermining the integrity of the presidential election. The petitioners contended that a significant number of Forms 34B had been executed by persons not gazetted as returning officers and not accredited as such by the first respondent, and that such election results as were carried in such forms were invalid. They contended that all returns submitted without IBC's official stamp or which did not bear the signatures and particulars of returning officers and agents were invalid. The petitioners averred that the returns used in a material number of polling stations were not in the prescribed Forms 34A, 34B, contrary to Regulations 792A and 87(1)A, and that the Forms 34B bore fatal irregularities affecting 14,078 polling stations out of the established 25,000. They contended that a number of the forms and returns were not signed, and they contended that some did not show the name of the returning officer, that some did not bear the IEBC stamp, that some Forms 34A and 34B did not bear the signatures of candidates' agents, nor the reason for lack of signature, that some were signed by some presiding officer serving at different polling stations. The petitioners contended that the first respondent had violated their rights under Article 35(2) of the Constitution by putting up inaccurate information which misled the general public. They also asserted that the presidential election was compromised by intimidation and improper influence or corruption, contrary to Article 81(e)(2) of the Constitution, as read with the Elections Act and Regulations 3 and 6 of the Electoral Code of Conduct. On the basis of the foregoing contentions, the petitioners formulated certain specific issues for the cost determination. These were: 1, whether the presidential election was conducted in accordance with the Constitution; 2, whether the presidential election was conducted in accordance with the written law; 3, whether the first respondent's non-compliance with the Constitution and or the law affected the result of the presidential election; 4, whether the first respondent's non-compliance with the Constitution and other law affected the validity of the result of the presidential election. 5, whether the non-compliance, irregularities, and improprieties affected the validity of the results of the presidential election. 6, whether the non-compliance, irregularities, and improprieties affected the result of the presidential election. 7, whether the exclusion of 2.6% of the total votes cast as spoiled votes substantially affects and or invalidates the count and tally of the presidential election votes. 8, whether the total number of verified rejected votes should be considered in ascertaining the attainment by any candidate of the constitutional threshold. 9, whether the third respondent was validly declared as president-elect. 10, whether the said third respondent committed election irregularities. 11, what are the appropriate orders to be issued by the court? That brings us to the evidence question. What is the evidence? The various contentions and averments, as a matter of vital judicial methodology, are to be lighted up by objective evidentiary account. I will now consider the scope of validation for the petitioner's cause coming forth by way of their main body of factual testimony. The first respondent, Mr. Odinga, tendered evidence by his affidavit of the 18th of August 2017, which also represented the stand of the second petitioner. He deponed that he had been a presidential election candidate duly nominated by the NASA coalition. The first petitioner deposed that the first respondent, acting through presiding officers, undertook the vote count, which culminated in the declaration of the third respondent as president on the 11th of August 2017 with 8,203,290 votes as against the deponent with 6,762,224 votes. The deponent was aggrieved with the declaration as he believed the presidential election to have entailed breaches of the Constitution and the applicable laws. Such breaches arising before polling day as well as during the process of tallying and transmission of results. The deponent stated his belief that the presidential election failed to meet the constitutionally prescribed terms that require free, fair, transparent, accountable, credible, and verifiable elections. He deposed that the IEBC had deliberately and or negligently compromised the security of the Integrated Electoral Management System, the KIMS, and thereby exposed it to unlawful interference by third parties. He deponed that the collation, tallying, verification, and transmission of the presidential election results had been compromised by procedural flaws and illegalities upon such a scale as substantially qualified the credibility of the declared result. He averred that the poll results as declared were substantially at variance with the actual results tallied and declared at the gazetted polling stations. He deponed that the respondent, in concert with cabinet secretaries and others serving under the charge of the third respondent, had abused their positions by bringing their influence and pressure to bear upon the potential voters. The deponent averred that while the first respondent had acted by virtue of Section 44 of the Elections Act and developed the Elections Technology Regulations 2017, under which the KIMS system had been set up for the management of elections, The failings in the conduct of the presidential elections had now undermined the security of the electoral system, exposing it to third-party interference. He deponed that the said electronic system had been misapplied, with the effect that the presidential election was substantially conducted by manual processes. As an instance in that regard, the deponent averred that the first respondent acted contrary to law by failing to transmit electronically the vote count results from the polling stations and the constituencies, with the consequence that the transmission process was now exposed to unlawful manipulation. He averred, in that context, that the consequential delay in transmitting election results with the prescribed forms gravely affected the credibility and validity of the results. The deponent averred that a review of the election results in relation to the available forms 34A and 34B had shown substantial qualitative anomalies, such as put into question the credibility of the presidential election. The deponent averred that the third respondent was guilty of undue influence, bribery, inducement, and intimidation in relation to the free exercise of elective preference by the voters. In this regard, the deponent averred that the third respondent had, on the 2nd of August, at Makueni, issued threats to those chiefs who did not mount political campaigns in his favor, that the cabinet secretaries had actively campaigned for the third respondent, that the third respondent had taken decisions involving public resource deployment in such a manner as to benefit his political campaign. Another deponent, Ms. Oichoe, averred that she was a cybersecurity expert and had observed and followed the conduct of the 8th of August 2017 general election, in particular the process of vote count results transmission. The process, as she averred, entailed 6 primary scenarios in respect of which IEBC's operational systems and database had to be tested. The first was confidentiality, the second was integrity, the third was authenticity. There are a number of them. And as far as she was concerned, the first respondent had failed in all those respects, and therefore the transmission system was entirely questionable. Another deponent, Mr. Koitameto Lekina, averred that he was a duly accredited agent of the NASA coalition in the general election of the 8th of August 2017. He deposed that he had arrived at the IEBC coordinating base, the Bomas of Kenya, on the election date at 16:30 hours for the purpose of activating his access card. Following some delay in activating the card, the deponent joined the company of fellow agents and they witnessed the streaming in of election results, which commenced at 17:15 hours. Thereafter, he averred his team came to learn that it was not possible to verify the result announcements as they came unaccompanied with hard copies of Forms 34A or the soft copies from the server. The NASA team, being concerned, approached IEBC commissioners, Professor Gulie and Ms. Roslyn Akombe, and the CEO, Mr. Ezra Chiloba, calling for Forms 34B as a basis of verification. As this initiative proved ineffectual, the deponent averred the NASA agents demanded a meeting with the Commission and obtained yet another fruitless promise of access to Forms 34A, these being received with Forms 34B only in limited numbers on the 11th of August 2017. The deponent recorded his opinion regarding the unreliability of the supply of Forms 34A and 34B by the IEBC, that this was evidence of a determination on the part of the Commission to declare results that could not be verified as required by law. The deponent drew on the content of another affidavit by Dr. Uduo and averred that dilatory responses to the demands for the said forms showed the first respondent's announcements to have been misinformed and or based on information such as failed the test of verification, accuracy, transparency, credibility. Mr. Moses Wamuru, the NASA presidential candidate's chief agent and coordinator for Embu County, deponed that he and his agent colleagues had not only been harassed, but kept out of the polling station by IEBC officials and officers of the provincial administration for most of the election day. He deponed that he had been forced by the constituency returning officer to sign the election declaration form as a condition for being availed a copy of the election results. Another deponent, Mr. Godfrey Osotsi, for Amani National Congress of the NASA coalition, averred that he was an ICT expert who had been an observer of the August election vote tallying. This deponent deposed not upon the settled fact, but urged this court to order a system audit to trace transmissions so as to reveal the code used by IEBC for the more than 40,000 polling stations for the purpose of identifying the IEBC officers who used such codes to transmit election results, to establish the time and place where such transmissions were originated, and to identify the person who applied the special identifier to effect results transmission. The deponent also gave his opinion on matters of law, that under the Election Act, election material includes systems such as are contemplated under Section 17(1) and include the KIMS, which incorporates voter registration, voter identification, and the results transmission system. The deponent proceeds on that same line of averment. A declaration of results has to come in the wake of transmission in the right manner as prescribed before reaching the National Tallying Center. He rested his affirmations upon other deponent's statements in support of the petition. As at the time of declaration of presidential election results, only 29,000 forms 34A had been received, and their authenticity still stood to be ascertained, and election results could only be declared when the Commission was already in possession of all the forms 32A and 32B. The deponent averred that IEBC either lacked full control of its system or ceded such control to some other authority. Another affidavit was sworn by Mr. George Kegoro, the Executive Director of the Kenya Human Rights Commission, a civil society agency committed to fostering and safeguarding human rights, democratic values, human dignity, and social justice. He deponed that his organization serves as secretariat for an initiative known as Kura Yangu, Sauti Yangu, KYSY, which is wholly devoted to the cause of fair elections during Kenya's 2017 election cycle. He averred that KYSY had deployed some 500 agents in all the 290 constituencies to observe and monitor the electoral process, and KYSY had found contradictions and anomalies in the election data emanating from IEBC, especially in relation to the presidential votes as reflected on the IEBC website. An agent of the NASA coalition, Ms. Olga Karani, deponed that concerns had been expressed by members of the public about anomalies and irregularities in the vote tallying process. Such anxieties also coming from the election candidates as well as NASA agents. She averred that the prescribed election forms were manually availed to the National Tallying Center, though sometimes they were also displayed on the IEBC website. It was a belief that it was impossible to verify the authenticity of such forms. She deponed that by the time of announcement of the election results, the Commission had neither collected nor availed any of the Forms 34B, nor had it responded to outstanding issues regarding Forms 34A or to the questions being raised about results posted on the website. She attributed lack of transparency to the actions taken by the first respondent. Another deponent upon whose averment several of the petitioner's witnesses relied was Dr. Nyangasi Oduo. He deponed that on the 8th of August 2017 at 5:07 p.m., some 10 minutes after the closure of the polling stations, the first respondent started streaming results for the presidential election. He averred that such announcement of results had maintained a constant gap of 11% between the vote count for the first petitioner and the third respondent, notwithstanding the random distribution of the constituency locations. His averment expressed suspicion also on the basis that, as he perceived it, in numbers of polling stations within the central Kenya and Rift Valley regions, the petitioner's agents were chased away from the stations and replaced by imposters. And thereafter, presiding officers were caused to record fictitious results in favor of third respondent. Dr. Oduo averred that upon being asked by the petitioner to examine 5,000 Forms 34A supplied by presiding officers to the first petitioner's agents across the country, and to compare these with Forms 34B supplied by the first respondent and Forms 33A posted on the first respondent's website, he found discrepancies. Dr. Oduo made averments embodying opinion in clear terms. He asserted that the third respondent and the deputy president, who were candidates in the presidential election, were guilty of corruptly influencing voters in the run-up to the general election of the 8th of August 2017. He averred that the election was compromised by instances of undue influence, inducement, bribery, intimidation. The deponent, in a second affidavit, avers that certain anomalies had compromised the said election. Instances being forms marked with a rectangular rather than an official circular stamp, returning officers failing to sign Forms 34B or recording their own names, lack of handing over notes, discrepancies in numbers of valid votes, unstamped forms, corrected figures noted on forms, agents not signing statutory forms, discrepancies in vote tally. Discrepancy in vote tally records was also the subject of averments by Mr. Benson Wasonga, who deponed that the IEBC summation of valid votes was 15,179,717, with the first petitioner having 6,821,505, the third respondent having 8,222,862, and the total rejected votes being 477,195, as compared to the IEBC portal showing as total votes cast 15,181,381, first petitioner's vote as 6,821,877, third respondent's vote as 8,223,163, and rejected votes as 403,495. These figures, it was deponed, varied from the specific figures in Form 34C that were issued at the time of declaration of the third respondent as the leading candidate. Total valid votes as 15,114,622, first petitioner's votes as 762,224. Third respondents votes as 8,203,290. Total rejected votes as 81,685. The deponent deposed that the actual variation in the rejected votes as between the IEBC summation of the results and the display on the portal was 73,700 votes, and he averred that this differential amounted to violation of the electoral law to the prejudice of the presidential candidates other than the declared winner. The petitioners called two more witnesses, one of these being Mr. Mohamed Noor Bare from Mandera, and the other one being Mr. Ibrahim Mahmoud Ibrahim, who said that they had been excluded from the polling stations. We have to look at the respondent side. Judicialism, the established framework for relieving the all-so-frequent grievances, conflicts, frays, and tensions in the social order, has evolved a civilized tradition of durable rules and methods of accommodation. Such methods have their objectivity and rationale lodged within the discipline of law, which, as will become evident in this judgment, is the domain not of the most open-textured manifestations, not the most elementary political suasions, but of jurisprudence as methodical reasoning of a normative and professional category. The established judicial method, which rests on the singular dependability of the fact base and which vindicates the principles of fairness, objectivity, and legitimacy, is to entertain the account from the other side, and therefore to weigh, check, and balance the true streams of evidence, thereby arriving at a valid and just result. As I express this introductory perception, so as to shed more light on the instant matter, I admit my debt to legal scholarship. With Andrew Goodman in his learned work, How Judges Decide Cases, in which he observes, quote, however rarefied and abstruse the legal argument before the court, it must be anchored on the facts of the case. While the judges will feel free to expound upon the most general principles in order to provide guidance for the future, the actual decision will turn on the facts, even if the detail of the argument is quite remote from them. End of quote. Such is a fundamental principle invariably observed in the practice and application of law in this country as in other countries, the constitutional and judicial systems of which have benefited from the integrity of the common law tradition. And such an approach is certain to lead to a fair, dependable, and plausible basis of judgment, as well as set a just and tenable reference point for the future. Let's look at the issues and contentions coming from the respondent side. It was the first and second respondent's assertion that the third respondent in the presidential election of the 8th of August 2017 had garnered the largest number of votes and had satisfied the constitutional threshold prescribed in Article 138(4) of the Constitution, apart from complying with the terms of the applicable statute law. They denied the petitioner's claims of non-compliance with the terms of Article 1, 2, 4, 10, 38, 81, 82, 86, 88, 138, 140, 163, and 249 of the Constitution, as well as other applicable laws, asserting that all such claims of non-compliance were couched in bare generalities and were devoid of any factual basis. The first and second respondents stated that the conduct of the presidential election had been attended with an elaborate management system guided by all relevant electoral laws and safeguarded by definite safety measures for assuring transparency, accountability, verifiability in terms of Articles 81 and 86 of the Constitution. The first and second respondents stated that they had duly verified and accurately tallied the election results for all candidates before declaring the outcome in accordance with Article 138(10) of the Constitution and duly taking into account the terms of the recent Court of Appeal decision in IEBC against Maina Kiai, Civil Appeal number 105 of 2017. They denied the petitioners' claims that they had conducted the electoral process in a manner that prejudiced the sovereign will of the voters and that they had only delivered, quote, preconceived and predetermined computer-generated leaders, end of quote. The first and second respondents denied the petitioner's allegation that the number of rejected votes in the presidential election had been as much as 2.6%, and the total votes cast, stating that such votes, as declared in Form 34C, constituted only 0.54% of the votes cast. The first and second respondents contested the petitioner's claim that the right principle to guide this court in respect of the treatment of rejected votes should be that preferred by the Seychelles Supreme Court in popular democratic movement against Electoral Commission. The respondent's stand was that rejected votes had been rightly excluded from the count of votes cast by this court. The respondent stated that the process of relay and transmission of results from the polling station to the constituency tallying center and the national tallying center had been simple, accurate, verifiable, secure, accountable, transparent, and prompt. The first and second respondents stated that the presidential election had been conducted in a manner that was free, fair, and in accordance with the Constitution, a manner that gave fulfillment to the sovereign will of the voters. The respondents urged that in these proceedings, two basic questions fell for determination, namely, first, whether the third respondent was validly elected and declared as president-elect by the second respondent, and secondly, what consequential declarations, orders, and reliefs the court should grant. They asked the court to find, with regard to the two questions, that, firstly, the respondents had not contravened the provisions of the Constitution, the Elections Act, or any other statute. Secondly, the presidential election was conducted in accordance with the Constitution and the Elections Act and all other relevant statutes, and a valid declaration of the outcome duly made. Thirdly, that the third respondent was validly elected as the President of the Republic of Kenya. Fourthly, that the people of Kenya exercised their sovereign power of the vote and their decisions should be respected. Fifthly, that the petition lacks merit and should be dismissed. Sixthly, that the petitioners should bear the cost of the petition. We'll go through some of the evidential statements. The second respondent, in his affidavit sworn on the 24th of August 2017, deponed that he had been the returning officer for the presidential election of the 8th of August 2017. He averred that neither he nor the first respondent had any private stake in the election outcome, and they had been neutral referees, their sole mandate being to provide the electoral structure for the voters to exercise their sovereign will by electing leaders of their choice. The deponent averred that a tally of all the votes had shown Uhuru Kenyatta to have garnered 8,203,290 votes, followed by Raila Odinga, the first petitioner herein, who garnered 6,762,224 votes. The declared results were expressed in Form 34C, which was itself abstracted from Forms 34B, forwarded to the National Tallying Center from the constituency tallying centers, as well as the diaspora vote tallies. The deponent averred that in view of the election management infrastructure that was in place, the primary results declaration forms, Forms 34A and 34B, were by no means compromised in their accuracy and overall integrity. These forms had been transmitted through the KIMS electronic system in a scanned format secured by non-replicable features. The security features, he averred, included anti-photocopy and self-carbonated elements up to a span subsuming 6 copies. He deposed that the presiding officers at the 40,883 polling stations were required to scan and electronically transmit the original Forms 34A to both the constituency tallying centers and the National Tallying Center. The constituency tallying centers, for their part, were required to relay the Forms 34B to the National Tallying Center for the purpose of tallying. And so, for the presidential election, the results could be verified by reconciling the figures in Forms 34A. The deponent averred that his dedicated task in the said electoral process was to provide policy leadership and strategic direction to ensure that the Commission's infrastructure for election management was accountable, efficient, systematic, methodical. He deposed that though afflicted by challenges occasioned by a multiplicity of suits against the Commission, it still ensured that the procurement of electoral materials by the Secretariat was done in a transparent and timely manner, and that other electoral processes, including supportive technological systems, were deployed in a manner consistent with the constitutional and legal requirements of simplicity, accuracy, verifiability, security, transparency, accountability. The deponent averred that all due arrangements had been made by the Commission in aid of the electoral process of the 8th of August 2017, noting in particular the following aspects. 1, voter education had been conducted throughout the country. 2, staff training for the management of elections had been duly carried out. 3, all the polling stations had been duly gazetted. 4, the register of voters had been duly audited and uploaded in the Commission's website, and hard copies printed and posted at conspicuous sites at each polling station. 5, mechanisms were put in place to facilitate the observation, monitoring, and evaluation of elections in compliance with the terms of Article 88.4 of the Constitution. 6, the procurement and distribution of strategic and non-strategic election materials was duly completed. 7, as required by Article 10 of the Constitution, the Commission had held many consultative meetings with key stakeholders, including, quite significantly, political parties, to update them on the progress made on all fronts in relation to the 8th of August 2017 elections. And 8th, the Commission had duly complied with the recent decision of the Court of Appeal in the Maina Kiai case on the conditions attending the tax tasks of vote counting, tallying, verification, and declaration of presidential election results at the constituency level and at the National Tallying Center. The deponent averred, in the light of the foregoing safeguard measures taken, that it was not true, as alleged by the petitioners and their witnesses, that the Commission presided over a shambolic presidential election, or that the entire electoral process was a failure, or that the election entailed breaches of the Constitution and the applicable laws relating to vote tallying and to the transmission of results. The deponent averred that the presidential election had met all the requirements of free and fair elections, having been conducted by way of secret ballots, being free from violence, improper influence or corruption, having been administered in a dedicated process conducted exclusively by the Commission, having been transparently conducted, and having been administered in an impartial, neutral, efficient, and accountable manner. The course of action which it took following that throughout the electoral cycle, that discharges mandates in perfect accord with the Constitution, the electoral laws, and the applicable regulations. He averred that in the discharge of his obligations at election time, he had not been anyone and had maintained the required standards of professionalism. The deponent deposed that he had conducted and supervised the election in accordance with the terms of Article 81E of the Constitution. Ballot. Secondly, polling stations were adequately secured by police to ensure that the electoral process was free from violence, intimidation, improper influence, or corruption. 3, the election was independently conducted by the Commission. 4, candidates and observers were allowed to have their appointed agents at the various polling stations to observe the voting process and to assure transparency. 5, the said agents observed the closure of the voting process and were involved in the counting of votes at the various polling stations to bear witness to manifestations of transparency, impartiality, neutrality, efficiency, accuracy, and accountability in the voting and vote count. And 6, the agents of the presidential election candidates were given access to the various vote recording forms, including Form 34A and 34B, a further element in the first respondent's transparency and accountability. The deponent averred, as regards the transmission set up during the electoral process, that the Commission staff managing the KIEMS gadgets had been trained in good time, and the said gadgets had been configured with the register of voters. He averred that the KIEMS system was designed to allow for integration of the biometric voter registration, biometric voter identification, the electronic transmission of election results, and the political party and candidate registration systems. He deposed that the said system had been successfully deployed on the 8th of August 2017 and that it had significantly The deponent averred that he was present at the National Tallying Center between the 8th and 11th of August 2017, participating in the tallying and validation of Forms 34B that were being electronically transmitted by the constituency returning officers, and in this regard, he attached as evidence copies of Forms 34B marked WWC3. Upon receipt of these forms, he deposed, he had collated the same and confirmed the consistency of the results available Forms 34B to presidential election candidates through their agents for verification and confirmation. The department thereafter used the said results to tally and complete Form 34C in compliance with Section 39(3)(b of the Elections Act. The deponent makes specific averments on the vote tallies as he received them on the 11th of August 2017. Now that chart is set out there, you'll be able to see it. The deponent averred that the Commission had found that in a few of the results declaration forms, there were certain errors, but that these errors were inadvertent, minor errors which had no effect on the vote tally and outcome of the presidential election. In support of the finding on the said errors, the deponent tendered in evidence a document marked WWC5, attended with a detailed affidavit of Madame Immaculate Kasait. Mr. Chebukati had specific averments to make in relation to certain depositions made on behalf of the petitioners. He deponed in relation to the statement by Mr. Godfrey Osotsi that throughout the electoral process, the Commission had engaged the petitioners as well as the third respondent in person and through their representatives, the public and interested stakeholders, for the purpose of adhering to best practices in electoral matters. The deponent, in departure from the testimony of Mr. Godfrey Osotsi, averred that the Commission was already in possession of all Forms 34B at the time of declaration of the presidential election results, and all the Forms 34B and 34C were available to the candidates and their agents for verification before the declaration of results. And all presidential election candidates were allowed to visit the National Tallying Center to verify the results, as from the commencements up to the moment of declaration. He averred that he personally chaired many consultative meetings with the petitioners' agents whenever any issues of concern had been raised, even though, for an explained cause, the petitioners' agents had decided to depart from the National Tallying Center just prior to the declaration of results.